Earlier this week, Special Counsel Jack Smith brought the Supreme Court into former President Donald Trump's legal battle. Now, in an unusual tactic, Smith bypassed lower appeals courts for a direct request asking the Supreme Court to consider whether the former president can claim immunity from criminal charges alleging that he interfered in the 2020 election. Now, the Supreme Court appears ready to expedite consideration of Smith's petition. But what was Smith's rationale, and what does this mean going forward? Where might it lead? Joining me now to discuss this is Jeff Clark, Senior Fellow and Director of Litigation at the Center for Renewing America. He was the Assistant Attorney General for the Environment and Natural Resources Division of the U.S. Justice Department during the Trump administration. Jeff, welcome to Washington Watch.
Thanks. I'm glad to be here, and I'm happy to talk about these important subjects. And the issues in particular that we're going to talk about, I think, are ones that I have long experience with in terms of being an appellate litigator.
Well, let's start right there. What's behind this? What is Jack Smith asking for, and why?
So he's asking for procedurally expedition and, in consideration of granting this, what you called unusual mechanism called cert before judgment, or more formally certiorari before judgment. So it leapfrogs the stage of the intermediate appellate court, which here is the D.C. Circuit. It goes right from the trial court, and the judge there in this January 6th related case against President Trump is Judge Chutkan, goes right to the Supreme Court if they grant it. So they've asked for a hurry-up decision on whether the Supreme Court uses that mechanism or not. And then substantively, what they want is a ruling that President Trump does not have presidential immunity to the criminal charges that Jack Smith, the special counsel, has brought, and that President Trump's argument that given that the charges highly overlap with the second impeachment trial in the Senate, where he was acquitted, that it would be double jeopardy to try him again.
So let's break that down, Jeff. This is, as you said, leapfrogging the appellate court. How unusual is this?
It's pretty unusual, but it's not unheard of. I mean, I think of the most important, case. The left likes to point to the Nixon case and say that happened there, where President Nixon actually was not a criminal defendant in that case. He was a third party who held records, right? He held the famous tapes. And, that it was granted in that case. But I don't really think that was the most important case. I think the most important case where there was cert before judgment in American history was the one where President Truman seized the steel mills during the Korean War, because without steel, it's hard to, press the war effort. And the Supreme Court took that case, using this mechanism, and they reversed his orders there and decided that presidents just lacked the power to seize industries. This is not, communist China or the Soviet Union.
This appears, Jeff, to have some correlation with the election. It seems that the special counsel is trying to get this decided before the president stands before the American people for election. Is that a factor?
I think it's more than a factor. I think it is the only factor, because look, the trial date here, which is set for early March by Judge Chutkan, it's not like that descended from heaven with a shout and trumpet, as it must be this date. It's just a date that she arbitrarily picked off of the calendar that she would like to use. Now, she has the discretion to do that. I think it was exercised unusually, because what's the rush? This is a complicated case. It's a very important case. I think that she's rushing it as well for political reasons. But in any event, she picked an arbitrary date and put it on the calendar. And Jack Smith is saying, we absolutely must leapfrog the D.C. Circuit here, go right to the Supreme Court, because otherwise that trial date is at risk. But that's just, compounding the arbitrariness of it, right? There's no external reason why this is something that has to be decided so quickly. The only plausible explanation for why it has to be decided quickly because Jack Smith wants to get a conviction potentially of President Trump before the 2024 presidential election. There's really no way around that. It's so patently obvious. And for that reason, I hope the Supreme Court sees its way to deny that petition for a writ of certiorari before judgment.
Well, Jeff, just an observation here, and feel free to bat it down. But from my perspective, and I think for many of our viewers and listeners, this is more of the type of political persecution that seems to be taking place toward this president, that it's more about keeping him out of office than anything.
I think so. I've expressed this to friends and colleagues in this way. I think, even if they are proceeding politically, but they wanted to try to have some plausible deniability of that, bringing one case they might think isn't enough because, what if one case fails? So you bring two cases. But at the point where you bring 3 cases, 4 cases, more cases, it starts to jump the shark, right?
Right.
It looks so patently obvious. And, it shows their desperation. It shows that they absolutely want to try to derail President Trump's, reelection efforts. And I think it's fundamentally illegitimate. And I wish more of the judges who had jurisdiction over these cases were calling out the Justice Department and Jack Smith over this.
And I think that the special counsel's actions here only heightens that concern, given the fact that you had to go back to Nixon or Truman to show a parallel when someone took such, as you said, not unprecedented but unusual action that was taken here.
Yeah, I mean, there's a handful of times where it happens. I just don't see how it meets the criteria because, I don't know. Another thing that happened today was the grant of cert in a case that involves abortion. And, in the abortion context, one of the classic sort of legal analysis of that, right, is that, the case could become moot potentially if the woman has an abortion, right? Or if you're talking about an election, right, at some point, if there's an inauguration, things become too set that they can't be undone. So there's kind of an inherent time fuse on it.
Right.
There's no inherent time fuse on this case. The only explanation is to try to interfere with the 2024 election.
I want to go to that case, the abortion pill case that the court has said that they're going to take up. But before I do, one other item that you brought up that's a part of this expedited request here dealt with, as you mentioned, kind of the double jeopardy, whether or not the president can be charged again with an allegation, a charge that he was impeached upon but not convicted. Explain that.
Sure. So, there was one count, as it were, right? One article of impeachment in the second Trump impeachment that related to January 6th. And that was essentially that President Trump had either engaged in an insurrection based on what he said that day and, his encouragement to his supporters to come to Washington, D.C. for the January 6th certification day, or that he had given aid and comfort to those who had engaged in insurrection. And you have to get, a supermajority of that for conviction in the Senate where impeachments are tried. And that case failed. And, I think it failed in 2 important constitutional respects. One, they didn't get the requisite number of votes from the senators. But second, I think recognizing what a sham the whole process was and that it was the first post presidency impeachment, attempted impeachment in U.S. history, the Chief Justice, who under the Constitution is supposed to preside over the trial, the impeachment trial, he did not show up. So they had to have Pat Leahy, the senator, stand in as kind of the quasi presiding officer in that case. So the argument is, look, that was the chance that the Democrats had to, eliminate President Trump from the, presidential, future races, et cetera. They tried, they failed. They're trying another mechanism, which I'm sure you've heard about, which is to try to get the individual states to keep him off the ballot by having them declare that he's disqualified under Section 3 of the 14th Amendment.
Right.
And that's, I think the argument that is blocked out by the the acquittal in the Senate is stronger even than the argument as it's applied here to the January 6th process.
Good point. I hadn't thought of that. Jeff, I want to switch gears here. You mentioned the Supreme Court announcing today that it will decide this term regarding the abortion drug mifepristone after the Biden administration appealed the Fifth Circuit Court of Appeals decision. So explain this case, what they will be looking at, and the implications here.
Sure. So this is a case where actually there were competing petitions on both sides. The petition coming from the pro-life side was denied, and two petitions from the so-called pro-choice side were granted. One by the Biden administration through the Solicitor General, and the other one from drug company that manufactures this abortifacient. And they were consolidated essentially. And so they will proceed to briefing and then, be argued. It should be a big case, right? And I think we would expect it to come down in the June 2024 timeframe. And as you noted, it involved granting review of a Fifth Circuit decision that didn't go back and void the original authorization by the FDA for that drug dating back to 2000, but basically found that more recent amendments to it to kind of lift safeguards that would protect women from complications from the drug and do things like require, consultations with doctors to check in on the women's health, that the FDA had failed essentially to properly analyze those. In that respect, it's a very basic administrative law case. It's a case where they're going to be looking to whether the Fifth Circuit was right, and to whether the FDA had analyzed the issues or whether instead the FDA was arbitrary and capricious. But there's one big question which has, I think far more important implications, which is the standing question. So the Solicitor General's, first issue in their brief, when they're trying to get certiorari, which they now have, is that there was no standing for doctors who, wanted to protect the cause of life, did not want to prescribe this drug. Do they have standing to challenge the FDA approval rule, et cetera? And, the Solicitor General in this administration says, no, they don't have standing. And, if they don't have standing, then you'd be in a spot where these abortifacients would be kind of off the hook, and the Biden administration could take off all of the governing processes, and the prescriptions would clearly go up, and therefore the abortions from drug rate would go up significantly.
Well, and that's already the case that we see over a majority, about 52% of abortions. And we don't know for certain because the FDA does not keep records on this. We don't have good accounting, but estimates are 52% of abortions are now through the drug, through the abortion pill. So some significant issues to be decided here. Jeff, I want to thank you for joining us. Very insightful, very helpful as we break this down. Thanks so much for being with us today.